Welcome to Day and Night News Prime Debate. Ever since the creation of the High Office of the Governor as the fulcrum of Indian federal system, it has remained as a controversial one. In context of the ongoing tussle between the Karnataka CM and Governor, the old debate thus has been brought back to life again. Should the Governor have a say in all the matters of the state, or should he just act on the advice of the government? That's what we debate in Prime tonight. The Constitution of India intends that the Governor should be the instrument to maintain the fundamental balance of the people of the state. It says the Governor should ensure that the mandates of the Constitution are respected in the state. However, how he exercises his position has always been mired in controversies.
An open political war between the Governor and the Chief Minister is going on in Karnataka. Karnataka Governor Hansraj Part1 has given a legal sanction to prosecute the Chief Minister B.S. Yediyurappa in alleged land scam cases. This move has brought the BJP and the Congress at loggerheads, with the BJP stating the move as political and illegal.
उन्होंने राज्यपाल के पद की गरिमा की अवमानना की है। हमारी राय है कि वे उनका आचरण संविधान के खिलाफ है, मर्यादाओं के खिलाफ है, परंपराओं के खिलाफ है।
Apart from taking legal action against the decision, the BJP has decided to go all out with a demand to recall Governor Hansraj Bhardwaj. The BJP says that the Governor has acted without the advice of the Cabinet and hence the decision is unconstitutional.
We know very well that he is going to order for prosecution. Before that, entire Cabinet taken decision not to go take any decision, because that is in the judicial inquiry is going on, and we are appointed for all this for the in High Court also cases is going on, and we are in order for the judicial inquiry. And if at all, if they got any complaints, the even Governor could have referred to this to the judicial inquiry. Why he has taken so much of personal interest?
Meanwhile, the Congress has supported the decision of H.R. Bhardwaj.
Nobody is above law or below. Nobody can escape the rule of law. Rule of law applies to the Chief Minister, Ministers and anyone. There is no exemption. While granting a sanction, he can't say that, since he is a Chief Minister, he is in immunity. He doesn't enjoy any immunity. When that is the case where, there is a proven evidentiary value for the corruption, he has no other option as a governor except to grant sanctions.
This episode has once again brought back to light the old debate on the role of governors. The credibility of the office of the governor has been questioned several times, as the office has been used as a president's agent of the centre in the states. Who has forgotten that decade of the 70s when the office was instrumental to cause the downfall of several state governments having majority in their respective assemblies? Such incidences did shake the people's faith in democratic institutions, and then they began to wonder whether the office of governor was worse than an expensive superfruity. In view of such incidents, some state governments had demanded for the abolition of the office of the governor or for a constitutional amendment to impeach the governor by the members of state legislative assembly. The H.R. Bhardwaj issue has added a new dimension to the ongoing debate on the role and responsibility of the governor in Indian states. Should the roles be redefined, or should this post be done away with?
To discuss the role of the Governor, we have in our studios Manjeet Singh Khera, Senior Advocate, Lieutenant General B.K.N. Chibbar, former Governor of Punjab, Justice T.S. Dwabia, former Judge of 2 High Courts, and Arun Sood, Advocate, who is also the General Secretary of the Chandigarh BJP. Welcome to the studio, gentlemen. General Chibbar, you've been the Governor of Punjab, just as Mr. Bhardwaj is now the Governor of Karnataka. Do you agree with what Mr. Bhardwaj has done? He's launched prosecution proceedings against the Chief Minister there.
Well, I personally think that he has acted within his rights.
Why do you say that? Is he not supposed to accept the recommendations of the Council of Ministers in that state?
Council of Ministers is Council of Ministers of the Chief Minister. But here the action was required against the Chief Minister himself. Governor is not guided by the Council of Ministers, that is the Chief Minister is guided by him.
But
So he has taken the decision according to his duties and rights, and main thing being that he is to protect the Constitution. The Constitution of the country says the man who does something wrong, he must be taken to task.
But General Chibber, we have to go by the provisions of the Constitution.
Yes, yes.
So to that extent, many legal experts feel that his decision is not constitutionally valid. I draw your attention to section 163 of the Constitution,
Yes.
which roughly says that there will be a council of ministers with the Chief Minister as the head to aid and advise the governor, except when required under the Constitution to use his discretion. Now, when is he supposed to use his discretion? Is this the issue where
This
he can
is a
use his
very
discretion?
interesting case for discretion.
This is an interesting case for,
Yes.
so you think this is just
This
the
is
case
one
where
where
he can
his
use his
discretion
discretion?
should be used. Otherwise, no council of minister of a chief minister who is in power will vote against him or will give this kind of a sanction against him. It just cannot be, because if that stage came, the gentleman would have resigned and gone.
Mr. Sood, you are a lawyer, so in your opinion, what is the constitutional position? Can the governor in this manner launch prosecution proceedings against the Chief Minister?
If we talking generally, then as per the section 197 of the CRPC, at the section 19 of the Prevention of Corruption Act, yes, being the appointing authority, governor is the authority to grant sanction. But in this particular case, governor has totally acted, his act is totally politically motivated, taking revenge against the BJP from the first day he has taken his office.
No, but Mr. Surya, I think you are contradicting yourself. If there is a provision to launch prosecution,
There is a
then how are you saying
procedure.
that this is politically motivated?
There is a procedure. He has violated that procedure. He being I said, being a appointing authority, he is the authority for granting sanction.
So what is the
But there
procedure
is a
which he has
procedure.
violated?
That I will said. There is a judgment quoted by today by Mr. Chidambaram, that there is a five bench judgment by the Honorable Supreme Court of India in Madhya Pradesh case. In that judgment, the Honorable Justice Hegde said that certainly the Council of Ministers has to first consider grant of sanction. However, on those rare occasions where on facts the bias come apparent and oblique, or the decision of Council of Ministers is shown to be irrational and based on non-consideration of relevant factors, the government would be right on the facts of that case to act in his own discretion and grant sanction.
So you think he has used that judgment selectively?
They have used that judgment selectively. They have not, the relevant part, they have not used it.
No, Mr. Sudi, you
can use
had
it
touched a very interesting point. Suppose the Council of Ministers does not provide the prosecution sanction. Can he still overrule the Council of
Yes,
Ministers?
then he can use his discretion.
Let me bring in Mr. Khera into the debate. Now, here is one advocate's interpretation of this judgment of the
Look
Supreme
here,
Court.
the myth that Chief Minister is answerable to the legislature only is now a myth, because of the 10th schedule, popularly known as anti-defection law. He can dictate the MLAs to vote in a particular manner. Till he loses majority in his own party, he can be a dictator. So the dictatorship of the party is there, only party can remove him. If he is corrupt, he is not going to recommend his own prosecution. And if the governor is deprived even of this discretion, where is democracy? We are having a dictatorship of one party. Here in this particular case, the party wanted him removed. His MLAs went away. They were prevented by using the leash of anti-defection law. His
But I
own
think,
partymen.
but he won the
But
test on
when-
the test on the floor of the House, Mr.
Not
Khera.
once,
This is what I am saying.
Twice.
By leash of anti-defection law. Not freedom of, this is what I am saying. The answerability to the legislature is a myth because of anti-defection law. We have taken it to a ridiculous extent, and this is the only democracy in the world which has a law which prevents a member from voting according to his own conscience. Here conscience is mortgaged to the party who gives the ticket.
Mr. Sood, would you like to react
And
to what
then-
Mr. Khera has said?
Mr. Khera, there was no defection in Karnataka Assembly. Some BJP MLAs revolted. and in that defection law, their membership was under consideration.
This is what I am saying. Precisely,
it's not it is not defection. It's some revolted.
There is a
provision of wit in the law.
Regarding to
so
their
party can issue
of defection
because they were elected on the symbol of the party.
That's what I am saying.
They are not independent. They have to follow the party guidelines.
I want to draw your attention to the Supreme Court order of 2004 of the 5-judge bench. This was headed by Santosh Hegde, who incidentally is the Karnataka Lokayukt at this point of time. The order stated the governor could act on his own discretion. Now, yesterday the well-known jurist Fali Nariman termed governor's action as improper. So clearly there are contradictory opinions. So that means the law is not settled on this.
Law is well settled, but the different situations demand different action. Here in this case, it is not the governor launching the prosecution. This is wrongly said. It is the two people who represented to the government with voluminous evidence that there has been corruption. This is the evidence. They only wanted the governor to allow them to prosecute, not that governor is prosecuting.
Mr. Khera, any 2 gentlemen or 5 gentlemen can approach the governor with some evidence and the prosecution can be launched.
Any citizen of this country who is concerned can approach the governor with evidence. Governor has to sift that evidence. After sifting that evidence, if the governor comes to a conclusion, there is a case for prosecution, not conviction. There is a prima facie case for
now it's very clear that there are 2 lawyers who are very clearly disagree. So let me bring in the judge with us here. Justice Dwabia.
I also want to
just a minute. Former Lok Sabha Secretary General Subhash Kashyap termed governor's decision as unfortunate, as painful. Would you agree that the prosecution sanction first has to come from the Council of Ministers, or at least that the opinion has to come from the Council of Ministers before the governor can actually initiate?
If we go by the judgment of 5-member bench of the Supreme Court, they have laid down the concept of bias. If a person is a party to a list, then the bias is apparent. He will not decide against him. And after citing number of judgments where persons participated in their own selection, the Supreme Court said, no, this all is bad. Now, this is exactly what has happened in this case. Normally, we have adopted parliamentary system of government. The governor is bound by the advice given by the Council of Ministers. That is the basic thing. But in this particular case, where you are going to prosecute the chief minister or a minister who is part of the Council of Ministers, any opinion given by them, don't prosecute, would be a biased opinion in their own favor.
Okay.
So this is precisely what the Supreme Court dealt with. And they said that in this situation, if the governor doesn't act, then the very foundation of democratic system would be in jeopardy. And with your permission, I'll read what in the ultimate paragraph the Supreme Court said. The facts in this case were that the Lokayukt of Madhya Pradesh had sanctioned prosecution.
This is for those 2 ministers.
2 ministers.
Yes.
And the Council of Ministers said no. And that decision of the Council of Ministers was challenged.
Yes.
So in those premises, what the court said, if on these facts and circumstances, the governor cannot act in his own discretion, there would be complete breakdown of the rule of law, in as much as it would then be open for the governments to refuse sanction in spite of overwhelming material showing that a prima facie case is made out. So this is what the Supreme Court has ultimately said, that this is where a person wants to decide